Welcome to this video on the Anti-Impunity Shield, deconstructing the ICC's jurisdiction post-withdrawal. We will conduct a forensic analysis of Article 127 and the legal anatomy of the Philippine situation. The core conflict lies between a state party's sovereign act of withdrawal and the International Criminal Court's institutional mandate. The key question is whether a state's withdrawal nullifies the court's jurisdiction over ongoing preliminary examinations. This jurisdictional chronology illustrates the overlapping timelines. Crucially, the preliminary examination commenced in February 2018, which was 13 months before the effective withdrawal date of March 2019. We see two fronts of accountability: the Rome Statute and the Philippines domestic law, RA 9851. Significantly, RA 9851 was enacted before the Philippines ratified the Rome Statute, embedding the anti-impunity shield domestically. The jurisdictional clash revolves around three main contentions. The defense arguments clash with the reality derived from the Office of the Prosecutor and statutory interpretations. Contention I addresses the semantic limits of Article 12. The defense argues the use of, quote, "our parties" means a state must currently be a party. However, legal reality requires a broader reading to include states that were parties when the crimes occurred. Contention 2 focuses on the institutional anatomy of the court. Article 34 proves that the Office of the Prosecutor is a constituent organ of the court, refuting the defense's argument that the court only means the judiciary. Contention 3 deals with the procedural phase. The defense claims a preliminary examination is merely, quote, "internal deliberation." However, Article 15.6 explicitly recognizes it as a formal stage, a matter under consideration. Article 127.2, the lex specialis, preserves jurisdiction. It states that withdrawal shall not prejudice the continued consideration of any matter already under consideration by the court. Since the preliminary examination was a formal matter commenced in 2018, the 2019 withdrawal cannot halt it. The drafter's intent was to close the escape hatch. Concerns raised by Amnesty International in 1998 led to the addition of the matter under consideration clause, ensuring withdrawal cannot be weaponized to guarantee impunity. Subsequent practice, the state's own conduct, further validates the ICC's continued jurisdiction. The voluntary surrender of Mr. Duterte in 2025, years after the withdrawal, demonstrates the Philippines' objective understanding that it remained bound by the ICC's jurisdiction for this specific matter. The anti-impunity shield is grounded in the textual reality of Article 127, the historical intent of the drafters, and the state's subsequent practice. To allow withdrawal to extinguish jurisdiction would defeat the preamble of the Rome Statute, as the court's jurisdiction is a permanent mandate to ensure that the most serious crimes do not go unpunished.
This is the brief on the ICC's investigation into the Philippines' war on drugs. So the International Criminal Court has officially stepped in to investigate tens of thousands of deaths tied to President Duterte's anti-drug campaign between November 2011 and March 2019, because they found a reasonable basis that crimes against humanity actually occurred. This is absolutely crucial to understand because we're looking at a massive state-sponsored campaign that literally hunted down its own citizens. First, let's look at the staggering scale. Official reports claim around 5,300 deaths, but actual estimates hit up to 30,000. I mean, how does a government just misplace 25,000 bodies? To put that into perspective, that's like secretly wiping an entire small town off the map. This deliberate policy, called Project Double Barrel, targeted impoverished urban men, mirroring an older hit group known as the Davao Death Squad. Second, we've got the Nanlaban cover-up. Authorities claimed suspects fought back. But seriously, how do you claim self-defense when the victim is literally shot in the back? Autopsies proved these victims were unarmed and pleading for their lives. Police were blatantly staging crime scenes, even recycling guns with identical serial numbers to justify lethal force, just like a terribly written script in a macabre theater production. Finally, the victims are fighting back. Despite a climate of absolute impunity and presidential promises of police immunity, 94% of victims favor this probe. Over 1,530 individuals and 1,050 families are represented at the ICC right now. Just think about the sheer courage it takes to stand up against the lethal state apparatus that systematically hunted them. Ultimately, the ICC is finally piercing through years of staged crime scenes and official impunity to seek justice for thousands of targeted, impoverished victims.
So, what happens when a country's signature policy is accused of being a crime against humanity? Well, that's what we're digging into today. We're heading to the International Criminal Court, where the Philippines' war on drugs is being put under the ultimate microscope. Our story starts right here, in The Hague. On September 15th, 2021, the International Criminal Court, the ICC, made a decision that basically put an entire government on notice. After taking a good hard look, an ICC chamber gave prosecutors the go-ahead for a full, formal investigation. Now, this wasn't just some procedural step, ticking a box. No, this was a massive, landmark moment.
Okay, so what exactly is this investigation all about? What's the scope? The details here are absolutely crucial to understanding just how serious this is.
The court was super specific about the timeline they're looking at, from November 2011 all the way to March 2019. And that timeline is so significant because it doesn't just cover the nationwide campaign that kicked off when President Duterte took office in 2016. It also goes back to cover earlier killings in the Davao area, which, looked strikingly similar.
And you really have to see the human element behind all this legal language. The chamber wasn't just sitting in a room making this decision in a vacuum. They looked at statements from over 1,500 individual victims and 1,000 families. And the result? It was just overwhelming. A whopping 94% of them wanted this investigation to happen.
So, to really get why the ICC authorized this, we have to wrap our heads around the sheer scale of the campaign at the center of it all, the so-called war on drugs.
Yeah, just look at this number. According to the prosecutor's estimates given to the court, the number of civilians killed in this campaign is just staggering. The figures they're working with range from 12,000 people to as high as 30,000.
Now, to get a handle on what the prosecutor is actually alleging, it helps to see how the court documents break down these killings. They basically fall into two main categories, and it paints a really vivid picture.
So on one side, you have killings that happen during official police operations, things like undercover buy-bust stings or these massive raids. But then on the other side, you've got these so-called vigilante-style killings. And the prosecutor's argument is that these weren't just random acts of violence. They allege that these were often carried out by assassins on motorcycles or paid killers who were actually coordinating with law enforcement.
And this brings us right to the heart of the conflict in the evidence. With thousands of people dead, how did the Philippine government officially explain it?
Well, the official story, time and time again, comes down to this one word, nanlaban. It literally means fought back. The government's consistent position is that these weren't executions. They claimed these deaths happened because suspects got violent, they resisted arrest, and that forced police to act in self-defense.
Right, but does it? You see, the chamber was presented with a mountain of information that seems to directly contradict that official story, and it raises some really serious questions about what was actually going on.
And this just shows you the kind of discrepancies the court was looking at. They had eyewitness accounts of victims literally surrendering or pleading for their lives. They saw forensic reports showing things that don't look like a firefight, like gunshot wounds to the back of the head. There were cases of people last seen alive in police custody. There were even reports from police insiders saying, hey, these crime scenes were staged. And then there's this little detail, get this, police reports showing guns with the exact same serial number being recovered from different victims in totally different places. So this is the crucial question. Do all of these alleged acts rise to the very high legal standard of a crime against humanity? Because, that's a very specific legal term.
The Rome Statute, the rulebook for the ICC, lays out a really clear three-part test. First, the acts have to be part of a widespread or systematic attack. Second, that attack has to be directed against a civilian population. And third, and this is the big one, it has to be carried out pursuant to a state policy. The prosecutor argued that the war on drugs ticked all three of these boxes.
Now, to prove that third point, that it was a state policy, the chamber looked at all sorts of public statements from top officials. This quote from Rodrigo Duterte, way back in 2009 when he was a city mayor, is just one example of the kind of rhetoric the court considered as evidence that these killings weren't just being tolerated, but were maybe even being encouraged from the very top.
So after looking at all the material they had, the chamber came to a pretty stark conclusion. They found there was a reasonable basis to believe this campaign wasn't a legitimate law enforcement operation. Instead, the facts suggested it was a widespread and systematic attack on the civilian population, all done in pursuit of a state policy.
Look, this decision to investigate is really just the beginning of a long, complicated legal journey. But it forces all of us to ask some really profound questions that go way beyond just this one case. Questions about sovereignty, about international justice, and about what happens when the very machinery of a state is accused of committing crimes against its own people. It's accountability on a global scale.
All right, let's talk about power. Specifically, how much power should one person really have? We're about to dive into a huge Supreme Court case from the Philippines that puts that very question on trial. It's a story that pits a president's authority right up against a nation's biggest international promises. And here's the question at the absolute heart of it all. Back in 2018, the Philippines just up and left the International Criminal Court. The thing is, the decision came straight from the president, totally sidestepping the Senate. And as you can imagine, that kicked off a massive constitutional showdown that went all the way to the country's highest court. Now, before we get into the fight, we've got to understand the main player here, the International Criminal Courts. You'll hear it called the ICC. So, what is it? Think of it as the world's permanent court for the absolute worst crimes imaginable. We're talking genocide, crimes against humanity, war crimes. It's really a court of last resort, designed to step in only when a country's own justice system can't or won't act. And you know, joining the ICC wasn't some quick, rash decision for the Philippines. Not at all. It was a long, careful process, a real national commitment that took decades and involved several different presidents. Just look at this timeline. It really shows you how much went into this. This wasn't one president's pet project. It was a national journey that took over 15 years. It started way back in '96 with President Ramos, kept moving forward under Estrada and Arroyo, and finally, President Aquino got it across the finish line. And that last step? A nearly unanimous 17-1 vote in the Senate. So this wasn't just some treaty. This was a policy woven right into the fabric of the nation. So, okay, after that super long, multi-decade journey to get in, what on earth could trigger such a sudden, whiplash-inducing decision to leave? Well, this is where the story takes a very, very sharp turn. The speed here is just staggering. In February of 2018, the ICC says, hey, we're starting a preliminary examination into the war on drugs. Less than a month later, the president declares, we're out. The very next day, a formal notice is sitting at the UN. It was this lightning-fast reaction that lit the fuse for the entire legal firestorm that followed. And bam, you've got yourself a classic constitutional standoff. It's a real tug of war. On one side, you have the senators. They're arguing, look, if our approval was needed to join the treaty, then you definitely need our approval to leave it. They basically said a president can't just undo a law of the land on his own. But on the other side, the executive branch fired back, saying the president is the sole organ for foreign policy and has the built-in power to withdraw. A true clash of powers. So the million-dollar question, how did the Supreme Court settle this? Well, their decision was absolutely fascinating because it came in two very distinct and honestly kind of surprising parts. First, the court basically said, you know what? It's too late. They declared the whole case moot. What that means is, from a practical, real-world standpoint, the withdrawal was already done. It happened. It was a fact. And here's a really powerful quote straight from the decision. The court called the withdrawal a fait accompli. That's a fancy way of saying it's an accomplished fact that can't be undone. The United Nations and the ICC had already gotten the notice and processed it. On the world stage, the Philippines was out. For the court to try and turn back time would be, in their own words, futile. But, and this is the really interesting part, the court didn't just stop there. Nope. Even though they dismissed the case, they did something incredible. They used this opportunity to write a brand new rulebook for any future president thinking about leaving a treaty. The court drew two crystal clear lines in the sand. A president cannot go it alone if, 1, the Senate, when it first approved the treaty, specifically wrote in a rule saying its approval is needed to get out, or 2, if leaving the treaty would break an existing domestic law. These are huge new checks on presidential power going forward. What this decision does is it basically sets up a version of what legal experts call the mirror principle in Philippine law. The idea is simple but really powerful. The way you get out of a deal should mirror the way you got in. It's all about keeping that delicate balance of power between the president and the Senate. So that brings us to the big so what question, right? If the court dismissed the case and didn't actually change what happened with the ICC withdrawal, why is this so-called moot decision so important for the future of the Philippines? Because this ruling isn't just about one president or one treaty. It's a permanent clarification of the rules of the game. It draws a much, much clearer map of the constitutional checks and balances for every single future administration to follow when it comes to foreign policy.
So why was this one specific withdrawal allowed to stand? Well, it all came down to a single number: 0. That's how many conditions the Senate put in its 2011 approval that had anything to do with withdrawal. It was a critical oversight, and it left the door wide open for the president to act alone.
And that leads us to the biggest lesson here, especially for the legislative branch. The Supreme Court essentially handed the Senate a playbook. The message is crystal clear. If you, the Senate, want to have a say in leaving a treaty, you have to explicitly write that condition into your approval right from the very start.
So, while a chapter closed when the Philippines left the ICC, a whole new one opened in its constitutional law. And it leaves us with this crucial question to think about. How will this new framework, this rebalancing of power, shape the nation's future on the world stage? It's a constant, delicate dance between the need for decisive action and the vital guardrails of democracy.
This is the brief on the Philippine Supreme Court's ruling on the ICC withdrawal. Back in 2019, the Philippines became only the second nation to officially ditch the International Criminal Court. And this Supreme Court decision finally lays out the ultimate playbook on how and when a president can pull out of an international treaty. First, why did petitions to stop the withdrawal fail? Well, it was basically moot because the UN already accepted it, and the Philippine Senate never officially fought the president. But listen, leaving doesn't erase the past. Think of leaving a group chat. You can leave, but you're totally on the hook for what you did while you were in it. Through a hook called residual jurisdiction, the ICC can absolutely still investigate past crimes. Second, what's the new framework for future treaty withdrawals? The president actually has executive leeway to leave unilaterally unless Congress specifically mandated the treaty or the Senate required its own approval to leave when they first signed it. Think of this conditional concurrence like a political prenup. If the Senate didn't put those exit terms in writing right at the start, the president can just walk away. Finally, does leaving the ICC create a dangerous legal vacuum? No way. The Philippines has its own domestic law, RA 9851, which offers even broader protections than the Rome Statute, including against sexual orientation persecution. Under the principle of complementarity, the ICC was always just a court of last resort, so the national courts are really the main event. Ultimately, while the Philippines closed the door on the ICC, the Supreme Court ensured that future presidents have strict boundaries for breaking treaties, and domestic courts remain the primary shield for human rights.
In March 2018, the executive branch of the Philippine government initiated a process to unilaterally withdraw the country from the Rome Statute. This treaty is the foundational document of the International Criminal Court in The Hague. By formally submitting a note verbal, the government signaled its intent to sever ties with the International Tribunal. On March 17, 2018, United Nations Secretary-General Antonio Guterres officially received and certified the notification. Under the explicit terms of the Rome Statute, that written notification to the UN is the sole requirement to initiate a withdrawal. By completing this step, the Philippines executed a legally binding diplomatic act on the international stage. Domestically, the decision triggered immediate and intense legal challenges from across the country. Several groups filed petitions before the Philippine Supreme Court, arguing the withdrawal was unconstitutional and demanding it be nullified. By the time the court reviewed the arguments, the United Nations had already formally acknowledged the withdrawal. The court recognized this as a fait accompli, a consummated action. Because the international process was complete and irreversible, the specific petitions were dismissed as moot. The court used the petitions as an opportunity to define the boundaries of executive power and establish a framework for how the Philippines exits international agreements. The root of the dispute lies in the 1987 Philippine Constitution. Article 7, Section 21 provides a clear directive. No treaty is valid and effective unless concurred in by at least 2/3 of all members of the Senate. The text mandates legislative participation to enter a treaty, but it provides absolutely no instructions on how to exit one. The executive branch interpreted this silence as an exclusive grant of power. Arguing that the president is the sole architect of foreign relations, the administration asserted it possessed the unilateral authority to terminate treaties at will. Legislators countered that this interpretation bypasses the Senate's constitutionally mandated role. If it takes two branches of government to validate a treaty, they argued, it should take two branches to nullify it. Allowing the executive to break treaties without oversight risks concentrating power. A single individual could dismantle foundational human rights commitments or trade agreements without any domestic check. The Supreme Court had to resolve this textual vacuum. Their task was to derive a constitutional mechanism that preserves the executive's agility in foreign diplomacy while enforcing the legislature's role as a structural limit. To build this mechanism, we must look at how international law interacts with the domestic legal system. They interface through specific constitutional rules. This flowchart maps those pathways. Under the doctrine of incorporation, customary international law bypasses legislative barriers and is automatically adopted as domestic law. But under the doctrine of transformation, treaties do not enter automatically. They must pass through a strict gate, Senate concurrence. The Rome Statute is a treaty. It falls strictly under the transformation doctrine, meaning it required active intervention from the Senate to hold legal weight inside the Philippines. Once transformed by that legislative act, the treaty becomes legally binding domestically. It shares the same force and effect as a domestic statute. Because it takes a legislative act to transform a treaty into domestic law, dismantling that treaty logically implicates the same legislative authority. To understand their hierarchy, we weigh their democratic inputs. A treaty is negotiated by the executive and concurred in by one chamber, the Senate. A domestic statute is more rigorous. It must survive 3 readings in both the House and Senate, plus final executive approval. This bicameral process ensures extensive participation from elected representatives across districts and sectors. Consequently, a statute carries significantly greater democratic weight than an agreement negotiated by a single person. This difference in democratic weight creates a strict rule of conflict. If a treaty and a domestic statute are irreconcilable, the statute prevails. This rule establishes the executive's baseline leeway. The president takes an oath to execute domestic laws. Therefore, the president is duty-bound to unilaterally withdraw from a treaty if it directly conflicts with the Constitution or a pre-existing statute.
The authority to withdraw isn't derived from an absolute prerogative over foreign policy. It is anchored in the president's constitutional mandate to prioritize domestic laws over international agreements. To define the exact limits of this withdrawal power, the Supreme Court looked to external legal models. They examined the mirror principle, articulated by legal scholar Harold Coe. As this reflection illustrates, the structural blocks required to build an international agreement should equal the blocks required to dismantle it. Under this principle, the degree of legislative approval necessary to exit a treaty must parallel the degree of legislative approval originally required to enter it. The court also considered the tripartite framework created by U.S. Supreme Court Justice Robert Jackson, which measures the ebb and flow of executive power against legislative intent. Arising from the 1950s steel strikes, the Youngstown framework categorizes presidential actions based on whether Congress explicitly authorized them, remained silent, or directly opposed them. Finally, the court reviewed Goldwater v. Carter, where the U.S. Supreme Court evaluated President Jimmy Carter's unilateral termination of a mutual defense treaty, weighing the absence of constitutional instructions against congressional authority. The Philippine Supreme Court did not adopt these foreign doctrines as binding rules. Instead, they utilized their underlying logic to construct a tailored, highly specific Philippine modality for treaty withdrawal. The resulting modality starts with the established baseline. The president can withdraw if a treaty violates the Constitution or a domestic statute. 3 strict limitations apply. First, conditional concurrence. If the Senate requires consent for future exit, the president cannot withdraw unilaterally. Second, an implementing statute. Withdrawing cannot violate domestic laws enforcing the treaty. Third, legislative imprimatur. If Congress mandated the negotiation, unilateral exit is stripped. In these 3 specific scenarios, treaty withdrawal is firmly established as a shared power. The executive and legislature are forced to act concurrently. By defining this 3-tiered modality, the court ended the doctrine of absolute, unchecked executive prerogative in international treaty abrogation. With this framework established, we look back at the immediate controversy. Why didn't the court apply these constraints to reverse the withdrawal from the International Criminal Court? The court tested the executive's action against the new limitations. First, did the Philippine Senate attach a conditional concurrence when they ratified the Rome Statute in 2011? The record showed they did not. Second, was there an implementing statute that the withdrawal would directly violate? We can track this on a timeline. Republic Act 9851, penalizing crimes against international humanitarian law, was enacted in 2009, 2 years before the Senate concurred with the Rome Statute. It independently replicated the treaty and expanded its scope before ratification.
Because these domestic statutory protections were already established and hold a superior hierarchical position, the court ruled that exiting the international treaty did not diminish the actual legal protection of human rights within the Philippine system. Ultimately, the petitions were dismissed. The United Nations had already accepted the withdrawal, removing any live, correctable controversy for the judiciary to act upon. Reversing a consummated international action without a clear, active constitutional breach would have been an overreach, demonstrating the necessity of judicial restraint in foreign affairs. While the procedural dismissal ended the immediate case, the ruling created a new doctrinal framework for executive power. The executive technically won the case and successfully withdrew from the Rome Statute. Yet, in doing so, the administration triggered the creation of a stringent legal framework that permanently restricts the authority of all future presidents. The Supreme Court utilized a legally moot case to meticulously map the boundaries of a constitutional vacuum. The decision in Pangilinan v. Cayetano reinforces the separation of powers by tethering the chief architect of foreign policy to domestic law and legislative intent.
This is the brief on the ICC's ruling to resume investigations in the Philippines. We're looking at a massive legal showdown here. The big question is, can the International Criminal Court investigate alleged crimes committed between 2011 and 2019, even after the country completely left the court? Think about it. If you cancel your club membership, can they still penalize you for breaking the rules while you were a member? First, in mid-2023, the court actually threw out the Philippines' attempt to stop this investigation on a pure technicality. The country argued the ICC lacked legal authority, but they totally failed to raise their withdrawal properly early on. It's literally like trying to challenge a referee's call after the game is completely over. The court basically said, "You missed your window." Second, even without that misstep, their defense was going to collapse under what's called complementarity. Basically, the ICC only steps in if a country isn't policing itself. The Philippines pointed to their internal police reviews as proof. But wait, is that enough? Absolutely not. The ICC requires a strict same person, same conduct test. You can't just turn in random homework, right? You have to prove you did the exact assignment, criminally investigating the exact same key figures for the exact same crimes. Finally, two dissenting judges issued a pretty stark warning. The Philippines formally withdrew back in 2019, but the prosecutor only requested investigation authority in 2021. So, does leaving the court actually mean anything? If a prosecutor can trigger an investigation years after you officially bounce, that exit door is basically locked from the outside. Ultimately, the ICC is moving forward because procedural missteps and weak domestic evidence outweighed the Philippines' claims of sovereignty, setting up a wildly complex precedent for international law.
So here's a tricky one for you. Can an international court keep investigating a country after that country has already quit? It's a huge legal puzzle, and it's playing out right now between the Philippines and the International Criminal Court. Let's get into it.
So picture this. It's 2019 and the Philippines makes a big move. It officially withdraws from the ICC, effectively cutting ties with the world's only permanent international criminal court.
Now you'd think that would be the end of it, right? If you leave a club, its rules don't apply to you anymore. So does that mean the ICC's investigation just stops? Well, when it comes to international law, it's rarely that simple. To really get why, we have to look at the exit itself and what it actually means. This is the first piece of our puzzle. Okay, so circle this date, March 17th, 2019. That's the day the Philippines' withdrawal from the Rome Statute, that's the treaty that created the ICC, officially became real. From that day on, they were no longer a member state. But here's where it gets really interesting. The crucial part of this story isn't just about when the Philippines left. It's about what was happening before they did. You see, the timeline of events is everything. All right, let's just walk through it real quick. Way back in November 2011, the Philippines joins the ICC. Everything's fine. Then, fast forward to February 2018, the ICC prosecutor opens what's called a preliminary examination. And literally just 1 month later, the Philippines says, "We're out," and sends in its official notice to withdraw. And that, as we know, took a year to become official. So, it all comes down to this very specific window of time, from when the Philippines joined all the way up to the day right before its withdrawal was final. This specific period is what the entire ICC case is built on. And this brings us right to the core legal idea that answers our big question. It's a rule that basically says you can't just walk away from your past responsibilities. Okay, before we go any further, let's just nail down a key term you're going to hear a lot: jurisdiction.
All it means is the official power to make legal decisions. So the whole debate here is whether the ICC still has that power for that specific time period. And the answer isn't some random opinion, it's written directly into the rulebook that the Philippines agreed to when it became a member in the first place, the Rome Statute itself. And here it is, the key phrase, straight from Article 127 of that treaty. It says a country is not freed from its obligations just because it withdraws. In other words, whatever you committed to while you were a member still stands.
The best way to think about it is like a gym membership. You can cancel it, and they'll stop charging you for future months. But you still have to pay for the time you were actually using the gym. Quitting is about the future, not the past. And this isn't just a theory they're floating. It's a principle the court has actually had to deal with before, which set a really clear precedent for this kind of situation. So, this leads to the two opposing views. The Philippines has argued that, look, once we were out, the ICC lost its power over us. But the ICC's position is not so fast. Our jurisdiction was locked in for any alleged crimes that happened while you were a member. And, this isn't the first time the court has had to deal with this. They faced a very similar challenge when the nation of Burundi withdrew from the Rome Statute a few years ago. In that Burundi case, the court was crystal clear. It ruled that a state's withdrawal, and I'm quoting here, has no effect on the previously established jurisdiction of the court. That ruling really cemented the idea that your obligations don't just vanish when you leave. So where does all of this leave us? Well, the legal arguments and the history all seem to point to one pretty clear, if kind of surprising, conclusion. At the end of the day, according to the ICC's own rulebook, the most important thing is that the Philippines was a member when the alleged crimes were committed. By joining the Rome Statute, they accepted the court's jurisdiction for that whole period. The timing of when an investigation officially gets started doesn't erase the jurisdiction that was already there. So, can the ICC prosecute a country that has quit? Well, based on the Rome Statute and the court's own decisions, the answer is a firm yes, but only for things that happened while it was a member. A withdrawal closes the door on the future, but it can't lock away the past.
This is the brief on the ICC's jurisdiction in the Duterte case. So, get this. In March 2025, former Philippine President Rodrigo Duterte was arrested and surrendered to the International Criminal Court regarding his war on drugs, even though the Philippines officially withdrew from the ICC way back in 2019. Wait, how can an international court arrest a leader whose country already quit the club 6 years ago? First, we've got to look at the timeline. The Philippines joined the ICC in 2011. Then, in February 2018, the ICC opened a preliminary examination into the drug war. Well, literally a month later, Duterte gave notice to withdraw the country from the Rome Statute, the treaty that actually created the court, which officially took effect in March 2019. Second, let's talk about Article 127, or the matter under consideration rule. The ICC ruled that since they started their preliminary examination in 2018, before the 2019 withdrawal was finalized, their jurisdiction was completely preserved. Think of it like this. It's exactly like trying to cancel your car insurance right after you've caused a massive pileup. You just don't get to escape liability for what happened while your policy was still active. Finally, we have the 2025 arrest. Duterte's defense tried to argue against this, but the ICC firmly rejected the challenge. They affirmed that a state's legal obligations remain for crimes committed while they were a party. Because of this rock-solid jurisdiction, the ICC issued an arrest warrant on March 7, 2025, and Duterte was surrendered to the court just days later, on March 12th. Ultimately, a nation simply cannot tear up its ICC membership card to outrun an investigation that has already started.
Okay, picture this. It's 2025. The world's highest court issues an arrest warrant for a former president. But his lawyers, they fire back with a pretty bold claim. You can't touch him. We already quit your club. So what happens next? Well, that's the unprecedented legal showdown we're diving into. So here's the timeline of how this whole thing went down, and it's all pulled straight from the court's own records. You see the Philippines joining, then leaving, and then boom, the warrant. It really all boils down to one massive question. Can a court try you for something you did when you were a member, even after you've already walked out the door? All right, so let's get into the nitty-gritty. How did this whole firestorm even start? Well, it all kicked off with one huge move from the court. And we're not talking about a minor charge here. This was for murder, as a crime against humanity. The court's allegation was that Duterte, while he was president, was the architect behind the massive and systematic war on drugs campaign. I mean, it's a huge accusation.
And almost immediately, Duterte's legal team launched a counterattack. But here's the fascinating part. They didn't try to argue he was innocent. Nope. Instead, they went straight for the jugular, attacking the court's basic right to even hear the case in the first place. Their whole argument, and this is pulled right from their legal filing, was pretty direct. They said, look, the Philippines officially left the ICC back in March 2019. So, according to the defense, the second that withdrawal became effective, the door for the prosecutor to open a new investigation just slammed shut. Kaput. In their eyes, the court had totally missed its chance. And right here, you're looking at the actual document they filed. This is key because it shows this wasn't just some political speech or an angry press release. This was a formal legal challenge aimed right at the heart of the court's authority, basically saying its power over this matter had expired. You know, this entire massive legal battle really pivots on this one little clause, Article 127(2) of the Rome Statute, which is the ICC's founding rulebook. It's supposed to deal with, unfinished business when a country leaves. But the big question mark is over that phrase, already under consideration. What does that actually mean? Well, as you can probably guess, the defense and the prosecution had two completely different takes on it. Okay, so the defense lays out what seems like a pretty solid argument, right? So how did the prosecution push back? Well, they came at it from a totally different angle, with their own interpretation of the rules. So you can see the fundamental clash right here. It's this one central question. Does quitting the club mean you get a free pass for everything you did while you were still a member? The prosecution's answer was a resounding no. They argued that jurisdiction gets locked in the moment the crimes happen. You can't just quit later on to dodge responsibility for what you've already done. It's not a get-out-of-jail-free card. And then, the victim's legal team jumped in with a really powerful moral argument. They basically said, hey, if a country can just bail to erase its past crimes, what's the point of this court? It would completely undermine the whole reason the ICC was created, which is to make sure powerful people can't just get away with the most serious crimes. Now, you might think the defense has a pretty strong case here, based on national sovereignty and all that, but the prosecution had a real curveball up its sleeve. And what's wild is they used the Philippine government's own actions as one of their most powerful pieces of evidence. This is where it gets really interesting. The new president of the Philippines, Ferdinand Marcos Jr., had been super clear, publicly stating his government wouldn't lift a finger to help the ICC. So with that kind of public opposition, how on earth could the prosecution turn that to their advantage? And this was the prosecution's masterstroke. They told the court to just ignore all the political talk and look at one simple, undeniable fact. Duterte was surrendered to the court. They argue that the act of handing him over, that action, proved that the Philippines, despite all its public statements, still recognized the court's authority for things that happened in the past. It was a classic actions speak louder than words argument. So the arguments were in, both sides had made their case, the stage was totally set. And the court's chamber, that's the group of judges looking at this initial phase, was about to make a decision that would absolutely send ripples through the world of international law. And the decision came down, clear as day. The chamber completely rejected the defense's argument. They sided with the prosecution, confirming that yes, their jurisdiction over the alleged crimes was still very much intact, even though the Philippines had withdrawn. So, what are the big takeaways from this huge decision? Well, first and foremost, leaving the ICC doesn't give you retroactive immunity. It's not a get-out-of-jail-free card for past actions. Second, the court absolutely keeps its power to prosecute crimes that were committed back when a country was a member. And finally, and this is a big one, a country's actions can speak louder than its words, showing what it really thinks its obligations are, no matter what politicians are saying. And so the case against Rodrigo Duterte rolls on, but it leaves all of us chewing on a really critical question for our modern world. When the power of a single nation clashes with the idea of international justice, which one should win out? It's something we're all going to be grappling with for a long time.
This image shows Rodrigo Duterte, the former president of the Philippines. In March 2025, he was arrested and surrendered to the International Criminal Court. The Philippines ratified the Rome Statute in November 2011, and the ICC prosecutor opened a preliminary examination in February 2018. In March 2019, the Philippines' official withdrawal took effect. This creates a distinct legal window, a bounded treaty period running from 2011 to 2019. The timeline immediately presents a procedural contradiction. The ICC officially authorized its investigation in late 2021 and issued the arrest warrant for Duterte in 2025. Both of these actions occurred years after the Philippines severed its treaty ties. The court asserts it maintains legal competence over this case. The justification relies on separating the existence of jurisdiction from the active exercise of it, a distinction governed by Article 127 of the Rome Statute. Resolving this paradox is critical to international law. If a state could unilaterally terminate the ICC's jurisdiction over past crimes simply by withdrawing from the treaty, the legal framework would collapse. This is paragraph 38 of the pretrial chamber's decision. The defense attempted to stall the jurisdictional roaming, arguing the chamber should first determine if Duterte was medically fit to stand trial. The chamber rejected this delay, ruling that jurisdiction is the central, primary issue that precedes all other legal questions. In paragraph 41, the chamber lays out its structural logic. Establishing jurisdiction is fundamental. Without it, the court has no competence to rule on any other procedural or personal matter, including a suspect's health. Resolving the jurisdictional question immediately also serves basic judicial efficiency. Proceeding with hearings without a confirmed jurisdictional basis risks a massive waste of institutional resources. This strict legal requirement stood in sharp contrast to the immediate concerns of the victims, who warned that delaying the proceedings or returning Duterte to the Philippines could result in severe retaliatory threats. Jurisdiction operates as the structural foundation of international criminal law. Without it, every subsequent action by the court is legally void. The defense builds its primary challenge around Article 12, Paragraph 2 of the Rome Statute, which outlines the preconditions for the court's authority. This section of the filing shows the defense differentiating between jurisdiction stricto sensu, the factual authority over specific crimes, and the active exercise of that jurisdiction by the court. They rely on a strict chronological interpretation. They argue that the preconditions for jurisdiction, specifically that the state is a party to the statute, must be satisfied at the exact moment the court decides to take action. This diagram illustrates their logic. Think of jurisdiction as an anchor. The defense argues the anchor must latch onto the 2021 formal investigation node. But because the Philippines severed its treaty connection in 2019, there is nothing for the anchor to catch. The defense concludes that because the Philippines was not a state party in 2021, legal preconditions to exercise jurisdiction over the case were entirely absent. This interpretation weaponizes the procedural lag of international investigations, turning the time required to build a case into a retroactive shield for former state officials. The prosecution counters this by resetting the timeline. They argue that jurisdictional preconditions must be satisfied when the crimes are actually committed, not when the legal machinery formalizes an investigation years later. By shifting the jurisdictional anchor back to the 2011 to 2019 window, the court's authority is firmly fixed to the territory and nationality of the Philippines, while it was a fully consenting state party. To resolve the withdrawal issue, the court relies on Article 127 of the Rome Statute. This article acts as lex specialis, the specific, controlling law governing exactly what happens when a state exits the treaty. This is the text of Article 127, Paragraph 2. The first sentence explicitly states that withdrawal does not discharge a state from the obligations that arose while it was still a party to the statute. This specific treaty language supersedes broader international norms, like Article 70 of the Vienna Convention, which the defense attempted to invoke. State withdrawal is forward-looking. Exiting the Rome Statute terminates future participation, but it cannot retroactively erase conduct that occurred while the treaty was in force. The core of the legal battle centers on the second sentence of Article 127, Paragraph 2. It states that withdrawal shall not prejudice the continued consideration of any matter which was already under consideration by the court. In paragraph 25 of their filing, the defense attempts to restrict the definition of the court to mean only the judicial organs, explicitly excluding the prosecutor from this protective clause. The defense further argues that a preliminary examination is an internal, informal process, and therefore cannot legally qualify as a formal matter under consideration. The pretrial chamber rejected this narrow semantic reading. They analyzed the statute holistically, prioritizing its object and purpose over fractured technical definitions. The chamber ruled that the specific subject matter of a preliminary examination, in this case the alleged crimes committed in the Philippines, absolutely constitutes a matter under consideration by the ICC as a unified institution. In paragraph 48, the chamber makes its definitive finding. The Duterte case falls squarely within the express provision of Article 127, preserving the court's jurisdiction. The legal definition of the word matter dictates the strength of the entire institution. A narrow reading creates a toothless assembly of treaties, while the broader interpretation maintains a functional, binding court. This revised timeline integrates the Chamber's ruling on Article 127. The February 2018 preliminary examination is highlighted as the critical anchoring event. Because it started before the 2019 withdrawal, it creates an unbroken line of legal authority stretching to the 2025 arrest warrant. The initiation of the preliminary examination legally anchored the court's jurisdiction. It ensured the matter was officially under consideration before the Philippines could close the treaty door. This neutralizes the chronological trap set by the defense. The court does not need to re-verify state membership when authorizing an investigation, provided the jurisdictional anchor was already set by an active inquiry. Once the prosecutorial machinery is set in motion within the legal treaty window, the judicial process becomes entirely independent of a state's subsequent attempts to revoke its membership. This is the final ruling in paragraph 48. The pretrial chamber formally rejects the defense challenge and affirms the ICC's active jurisdiction over Rodrigo Duterte. The implications of this ruling extend far beyond the Philippines. It establishes that a state cannot unilaterally extinguish international liability for its nationals by exiting the Rome Statute once an inquiry has begun. The Rome Statute is a binding commitment to international law. It is not a disposable membership that a government can discard when accountability becomes politically inconvenient. This ruling effectively closes the withdrawal loophole in international treaty law, ensuring that legal processes cannot be outrun by bureaucratic maneuvers. The architecture of the Rome Statute is designed specifically for this purpose. It ensures that the pursuit of accountability outlasts unilateral retreats, maintaining the rule of law even when states attempt to abandon it.
This is the brief on the ICC case against Rodrigo Duterte. We're looking at a legal timeline detailing how the International Criminal Court maintained jurisdiction to indict and detain former Philippine President Rodrigo Duterte for alleged crimes during his war on drugs, even after his country withdrew from the court. First, the crimes and the arrest. The ICC investigated alleged crimes against humanity tied to the anti-drug campaign between November 2011 and March 2019. A warrant was issued on March 7, 2025, and Duterte shockingly surrendered to the ICC just days later on March 12. It's kind of like trying to cancel your gym membership to get out of paying for the equipment you already broke. Second is the Article 127 legal trap. How do you arrest a non-member state's leader? Well, the Philippines' withdrawal took effect in March 2019, but the ICC had already opened a preliminary exam in February 2018. Duterte's defense argued this was informal, but the ICC shut that down, classifying it as a formal phase that preserves jurisdiction. Does merely opening a preliminary, seemingly informal examination really give a court the right to lock a sovereign nation into a permanent legal bind? Finally, the admissibility fight. In 2021, the Philippines asked the ICC to back off, saying they were handling it domestically. The ICC rejected this in 2023 because local probes didn't sufficiently mirror the ICC's investigation. Backed by representations filed on behalf of 659 families, it's clear you can't just pretend to grade your own homework to keep the international authorities away. Duterte's surrender proves that leaving an international treaty doesn't erase the past if the legal clock was already ticking.
In March 2025, the International Criminal Court took custody of former Philippine President Rodrigo Duterte, initiating a high-stakes standoff over international law. Following an unsuccessful attempt to disqualify the presiding judges, Duterte's legal team pivoted, centering their defense on a hyper-focused reading of the treaty's text. The core of the dispute lies in the timeline. The Philippines joined the ICC as a state party in August 2011, accepting the court's jurisdiction. In February 2018, the ICC opened a preliminary examination into allegations of crimes against humanity. Shortly after that examination began, the Philippines initiated its withdrawal, which became effective in March 2019, 6 years before the court issued an arrest warrant. This sequence creates a collision between treaty obligations and national withdrawal. Can a sovereign state grant itself retroactive immunity by leaving the court while an investigation is already in progress? The defense relies on isolating a single verb in the Rome Statute to argue that the court's authority evaporated the moment the withdrawal became effective. Their argument focuses on Article 12, Paragraph 2, which defines the preconditions for the court to exercise its jurisdiction. Specifically, the text states the court may exercise jurisdiction if the relevant states are parties to the statute. Because the Philippines was no longer a party to the statute when the arrest warrant was issued in 2025, the defense argues the preconditions for jurisdiction can no longer be satisfied. The Office of Public Counsel for Victims, or OPCV, countered this by applying the interpretive framework of the Vienna Convention on the Law of Treaties. They argue that if this isolated reading is accepted, the ICC's entire function is compromised, allowing any state to terminate an active investigation at will. The first stage of the Vienna Convention framework involves the principle of lex specialis, the doctrine that laws governing specific situations take precedence over more general provisions. In this case, Article 127 is the specific provision explicitly governing a state party's withdrawal. Paragraph 2 states that withdrawal shall not prejudice in any way the continued consideration of any matter already under consideration by the court. The timeline shows the preliminary examination began in early 2018. Because this matter was already under consideration before the 2019 withdrawal, the specific rules of Article 127 apply. This means that jurisdiction was locked in the moment the prosecutor began the examination, creating a legal obligation that survives the state's exit. When read alongside Article 127, the word "are" in the statute necessarily includes states that accepted jurisdiction at the time the legal... The second stage is teleological interpretation, which requires that a treaty be interpreted in light of its overarching object and purpose. The Rome Statute declares its fundamental mission in the preamble. The founders explicitly stated their determination to put an end to impunity for the perpetrators of the most serious international crimes. The defense's focus on the present tense verb would create a permanent loophole, allowing states to evade the court's reach by simply terminating their membership the moment they are investigated. The OPCV argues that such a result is manifestly absurd, as it would provide a legal mechanism to achieve the exact opposite of the treaty's stated goals. For the court to function, it cannot adopt an interpretation that would effectively legalize impunity and destroy the institution's reason for existing. The Travaux Preparatoires, the treaty's legislative history, further clarifies the text by revealing the specific intent of the drafters during the 1990s. The records of the International Law Commission from 1993 and 1997 show that the architects of the statute meticulously debated the legal effect of a state's withdrawal. They explicitly drafted language stating that withdrawal does not affect proceedings already commenced under the statute. This archival evidence confirms the court's contextual reading. The authors intended for the court's jurisdiction to be durable once the legal process was in motion. The historical evidence establishes that the authors identified, debated, and explicitly blocked this specific loophole decades ago. The final Vienna Convention metric is subsequent practice, the principle that a state's own behavior regarding a treaty serves as evidence of its legal understanding of that treaty. The Philippine government's own actions in 2025 provided this evidence. Despite their withdrawal in 2019, the Philippine authorities voluntarily surrendered Rodrigo Duterte to the ICC's custody to face the charges. This physical surrender constitutes a recognition of the court's authority and the state's continuing duty to cooperate on matters that began while it was a member. When a state complies with a warrant, it implicitly acknowledges that the court maintains jurisdiction, regardless of any later arguments about the tense of a single verb. The convergence of context, purpose, history, and practice overwhelms the defense's literalist claim. These elements form the foundation of crystallized jurisdiction. Once the prosecutor initiates a case under the Rome Statute, the court's authority over that specific investigation is set. It cannot be undone by a subsequent political decision to leave the treaty. This mechanism ensures that international law is an interwoven system of enduring obligations, rather than a collection of textual traps. This case ultimately defines the boundary between a nation's sovereignty and its international accountability. Sovereignty grants a state the right to terminate its future obligations under a treaty, but it does not allow a state to erase historical facts or the legal consequences of actions taken while it was a member. A withdrawal can dictate a nation's political path forward, but it cannot be used to retroactively delete the legal reality of an investigation that has already begun. The precedent set here confirms that the architecture of international justice is designed to outlast the shifting political strategies of individual states, ensuring that leaving the court is not the same as escaping its reach.
Imagine, for just a second, a former head of state sitting in a detention cell in The Hague.
Right.
The allegations against him are just staggering. We're talking massive, systemic crimes against humanity.
Absolutely.
And the international machinery of justice has spent years, literally years, building a case, securing arrest warrants, and finally actually taking him into custody.
Which is a huge hurdle in itself.
Right. But here's the crazy part. His defense team, they aren't arguing about the evidence.
No.
They aren't bringing in alibis or, debating the timeline of the alleged atrocities. Instead, the entire legal shield standing between this leader and a multi-year international trial hinges on, and I'm not making this up, a middle school level grammar dispute.
It really does. It comes down to the present tense conjugation of the word are.
A single word. They are arguing over the word are.
I know, it sounds almost absurd when you frame it that way. But in the realm of international law, text is absolutely everything.
Yeah, words matter.
Exactly. Sovereignty, the ultimate power of a nation to govern itself without outside interference. It's surrendered, word by word, comma by comma.
Wow.
So when a country signs an international treaty, they are meticulously parsing the language because those exact words dictate exactly when and how foreign judges can scrutinize their domestic affairs.
So a debate over the word are isn't just some semantic game.
Not at all. It is a full-blown battle over the fundamental limits of global authority.
And that is exactly what we are unpacking in today's deep dive.
Yeah.
We are looking at a incredibly high stakes, real-time legal battle happening right now in 2025 over the International Criminal Court, the ICC, and its jurisdiction regarding the Republic of the Philippines and its former president, Rodrigo Duterte.
Right, and it's a fascinating timeline.
We're going to explore how a country can spend decades helping build an international court, only to attempt this sudden unilateral exit the very moment that court turns its gaze toward them.
And to do that, the source material we have to guide us is incredibly dense, but really revealing.
Very revealing.
We are working with a massive 27-page legal filing from the ICC dated June 9, 2025. This document comes from the Office of Public Counsel for Victims, and it contains their formal observations on the defense challenge with respect to jurisdiction.
Which is essentially the counter-argument to that grammatical defense we just mentioned.
Exactly. We also have a related 2025 ICC judicial decision, specifically from the plenary of judges, which rejected a move to disqualify 2 judges from this exact case.
And to really understand how this international drama sparked a massive domestic constitutional crisis back home, we have a landmark 2021 Philippine Supreme Court ruling.
Right, the consolidated cases of Pangilinan versus Cayetano.
Yes, which details the brutal internal fight over whether a president even has the power to cancel a treaty on their own. It's an incredible stack of sources.
It really is. We are getting the perspective of international legal counsel representing victims, the internal rulings of the international judiciary itself, and the constitutional limits defined by the highest domestic court of the nation in question.
Now, before we dive into the actual mechanics of these documents, I need to pause and establish a really crucial ground rule for our discussion today.
Yes, very important.
The sources we are examining contain highly politically charged content. They involve deep, ongoing domestic Philippine politics, as well as highly sensitive international human rights allegations.
All right.
So we want to make it absolutely clear to you, the listener, that we are not taking any sides, nor are we endorsing the viewpoints of any political faction, left-wing or right-wing.
Exactly.
Our goal today is to impartially report on the factual content and convey the exact legal and historical arguments contained in the original source material. Nothing more, nothing less.
That neutrality is vital, you know. Our purpose here is to dissect the architecture of the legal argument.
Right, the mechanics.
Yeah, we are looking at the stress testing of international treaties. We want to understand how global justice operates when it collides with national sovereignty, regardless of the specific political figures involved.
Perfect. So with that framework in place, let's look at the foundational question that drives this entire conflict.
Okay.
If a country signs an international treaty, agrees to be bound by its rules, and integrates those rules into its own domestic laws, can they just cancel their membership the moment they fall under investigation?
It's the million-dollar question.
Right. I mean, think about it. If you crash your car into a tree, you cannot call your insurance agent the next morning, cancel your policy, and claim you are no longer subject to the deductible for an accident that happened yesterday.
Right, that wouldn't fly anywhere.
There is no get-out-of-jail-free loophole in a standard contract. But does one exist in international law?
Well, to answer that and to understand the sheer gravity of what is happening in The Hague in 2025, we really can't just look at the moment of the withdrawal.
We have to go back.
Way back. We have to trace the deep history, the decades-long relationship between the Philippines and the ICC. Because the narrative isn't just about a country deciding to leave a club.
No, they helped build the club.
Exactly. It is about a country that served as a foundational architect of the very institution it is now fighting.
So let's wind the clock back to the 1990s. The geopolitical landscape is vastly different. The world is reeling from the horrors of the former Yugoslavia and the Rwandan genocide.
Yeah, there was a palpable, urgent global momentum.
Right. A push to stop relying on temporary ad hoc tribunals and build a permanent standing international criminal court. And the Philippines wasn't just a passive observer in this process.
Not at all. They were actively holding the blueprints. Under the presidency of Fidel V. Ramos, the Philippines took a highly proactive stance. We're talking about March 1998, months before the Rome Statute was even finalized.
Over the day.
President Ramos issued a specific administrative order creating a dedicated task force solely focused on the proposed establishment of the ICC.
That implies a massive commitment to bureaucratic resources. I mean, They weren't just sending a junior diplomat to take notes in the back of the room.
Exactly. This task force was an interagency powerhouse. It was chaired by the Department of Foreign Affairs, co-chaired by the Department of Justice, and pulled in the Office of the Solicitor General, the Department of Interior, and local government.
Wow, everyone.
Yeah, and even academic heavyweights from the University of the Philippines College of Law. Their mandate was to generate policy recommendations, formulate the official Philippine negotiating position, and identify exactly what domestic legislative measures would be needed to align with this future global court.
So they were doing the heavy lifting before the foundation was even poured.
They really were.
So when the international community finally gathers in Rome in the summer of 1998 for the United Nations Diplomatic Conference, the event that actually birthed the Rome Statute, the Philippine delegation, arrives with a highly developed, specific vision for what this court should be.
And then they were incredibly vocal about that vision. The sources provide summaries of the speeches delivered by the Philippine delegation, specifically Foreign Affairs Undersecretary Loro L. Baja.
What was his main argument?
Well, he laid out a philosophy that championed efficiency and effectiveness, arguing that a court lacking the teeth to address impunity would be worse than no court at all.
Basically saying, don't build a paper tiger.
Right. But more importantly, the Philippines fiercely advocated for two specific structural pillars of the ICC. The first was the principle of complementarity.
Let's unpack complementarity because it feels like a concept that is going to haunt the later parts of this story.
Oh, it definitely does.
How does complementarity protect a sovereign nation?
Complementarity is essentially the ultimate safeguard for state sovereignty within the ICC framework. The Philippines argued that the ICC should never be a supreme, overreaching global Supreme Court that can arbitrarily snatch cases from domestic jurisdictions.
So it's not a higher court of appeals?
No. Undersecretary Baja explicitly stated that national judicial systems must always have primacy. They get the first right of refusal, so to speak.
So the ICC is legally designed as a backup generator. It only kicks in if the main power grid, the national courts, completely fails.
That is a perfect analogy. The ICC is a court of last resort. It can only step in and initiate proceedings if the national institutions are unwilling or unable to genuinely carry out the investigation or prosecution themselves.
Okay, so if a country is actively investigating its own citizens for a crime, The ICC has to back off.
Exactly. The Philippines fought for this because it allowed them to support international human rights without surrendering their ultimate authority over their own territory.
That makes perfect logical sense. You protect your sovereignty while still participating in the global moral consensus.
Right.
What was the second structural pillar they fought for?
The second pillar was about giving the court actual independence. They pushed for the creation of an independent prosecutor who possessed the power to initiate investigations proprio motu.
Proprio motu, on their own initiative. So we're talking about the difference between a detective who can walk the beat, follow a hunch, and open a file based on evidence they uncover themselves, versus a detective who has to sit at their desk waiting for the mayor to specifically hand them a written order to investigate someone.
That is exactly the distinction. The Philippines, represented by their alternate head of delegation, Franklin M. Ebjelin, explicitly praised the final draft of the Rome Statute because it granted the prosecutor this exact independent power.
Why was that so important to them?
Because they did not want a court that was entirely paralyzed by global politics. If the prosecutor had to wait for the UN Security Council to refer a case, any permanent member could just veto an investigation into their allies.
Right, it would just be a political tool.
Exactly. By giving the prosecutor proprio motu powers, they ensured the court had independent teeth.
So, to summarize their 1998 position, the Philippines wanted a powerful, independent prosecutor who could go after anyone, anywhere, but they also demanded a structural guarantee that their own domestic courts would always be respected first.
Yeah.
It is a very carefully balanced philosophy. And they were happy enough with the final document that they voted to adopt it.
They did. And on December 28, 2000, under a new administration, President Joseph Estrada of the Philippines officially signed the Rome Statute.
But as you know, in international law, an executive signature is often just an expression of intent.
Right. It doesn't instantly make the treaty legally binding on the country.
Right. Entering a treaty is usually a two-key system.
Yeah.
The executive branch negotiates and signs it, but the legislative branch has to unlock the domestic application.
Yes.
And in the Philippines, their 1987 constitution is very clear. A treaty is only valid and effective if it receives the concurrence of at least 2/3 of all the members of the Senate.
And this is where we see the depth of their structural integration, because the domestic ratification process took over a decade. It spanned multiple presidencies.
It wasn't rushed at all.
No. At one point, the Philippine Supreme Court was even petitioned to force the executive branch to send the treaty to the Senate, which the court declined to do, respecting the separation of powers. But the momentum just continued to build internally.
And this is a detail from the sources that I find so fascinating. Before the Senate even formally concurred on the international treaty, the domestic legislature went ahead and basically copy-pasted the ICC's rules into their own penal code.
Yes. In December 2009, under President Gloria Macapagal Arroyo, the Philippines enacted Republic Act 9851.
What did that do?
It is the Philippine Act on Crimes Against International Humanitarian Law, Genocide, and other crimes against humanity. They essentially localized the Rome Statute.
Wow.
They created a domestic legal architecture that mirrored the international one, ensuring that if these crimes happened, Philippine courts had the explicit statutory tools to try them.
Which ironically reinforces their beloved principle of complementarity.
Exactly. They were building the domestic grid so the international backup generator would never need to turn on.
That is brilliant.
And finally, under President Benigno Aquino III, the political alignment was perfect. On August 23, 2011, the Philippine Senate passed Resolution 546 with a staggering vote of 17-1, providing the formal concurrence.
17-1. That's near unanimous.
It is. The instrument of ratification was deposited, and on November 1st, 2011, the Rome Statute officially entered into force in the Philippines. They were now the 117th state party to the ICC.
So let's step back and look at the sheer weight of that history. We have 4 different presidential administrations over 13 years.
Right.
We have dedicated task forces, vocal advocacy at the foundational diplomatic conferences, the passage of massive domestic mirroring legislation, and a near-unanimous Senate vote.
It's monumental.
They did not just stumble into this treaty. They meticulously built themselves into the very fabric of the International Criminal Court. They are as locked in as a sovereign nation can possibly be.
Which is precisely why the next phase of our timeline is so jarring. It represents a geopolitical whiplash that few international legal scholars anticipated. We transition from this era of architectural integration to a period of intense friction, beginning with the election of President Rodrigo Duterte in 2016.
The political environment shifts dramatically, and the newly elected administration launches a highly publicized, highly aggressive national campaign regarding illegal drugs.
Yes.
And it doesn't take long for the international community, and specifically the ICC, to start receiving communications about this campaign.
Under the rules of the Rome Statute, specifically Article 15, any individual or group can send information to the prosecutor regarding alleged crimes.
Anyone can just send a tip.
Exactly. And in April 2017, a lawyer named Jude Sabayo filed a formal communication alleging summary killings related to Duterte's previous tenure as mayor of Davao City. 2 months later, in June 2017, two opposition lawmakers, Senator Antonio Trillines V and Representative Gary Alejano, filed a supplemental communication expanding the scope to include the national war on drugs.
So these communications act as a trigger. They land on the desk of the independent prosecutor, the very independent prosecutor that the Philippines fought to empower back in 1998.
The irony is pretty thick. The prosecutor at the time, Fatu Bensouda, reviews these communications. And on February 8, 2018, she makes a pivotal announcement. The Office of the Prosecutor is officially opening a preliminary examination into the situation in the Republic of the Philippines.
Okay, let's clarify what a preliminary examination actually means mechanically. Yeah. Is this a full-blown investigation with subpoenas and arrest warrants?
Not yet, no. A preliminary examination is an initial formal stage.
Like a pre-investigation.
Yeah, the prosecutor isn't sending investigators to the country to collect physical evidence or interview suspects yet. Instead, they are applying a rigorous legal filter to the information they have received.
What are they looking for?
They have to assess four things. Jurisdiction, meaning, did the alleged crimes happen on the territory of a member state? Admissibility, are the domestic courts failing to act, keeping that complementarity principle in mind? Gravity, are the crimes severe enough to warrant international attention? And finally, the interests of justice.
So the prosecutor is essentially saying, I have received enough credible information to warrant a formal, structured review to determine if we should open a full investigation. It is the first gear of the ICC machinery turning.
Exactly. And the reaction from the Philippine executive branch was immediate and explosive.
Explosive is an understatement. The preliminary examination is announced on February 8th, 2018. Just over a month later, on March 15, President Duterte publicly announces that the Philippines is withdrawing from the Rome Statute immediately.
Immediately.
The very next day, March 16th, a formal diplomatic document called a note verbale is submitted to the UN Secretary General. The UN receives it on March 17th.
And under Article 127 of the Rome Statute, withdrawal from the treaty takes effect exactly 1 year after the official notification is received by the UN Secretary General.
Okay.
So the withdrawal timer started ticking, slated to become effective exactly a year later on March 17th, 2019.
I have to stop here because this timeline is making my head spin.
It's incredibly fast.
It took 13 years, 4 presidents, domestic legislation, and a Senate supermajority to join this court. And it took one note verbale, delivered on a random Thursday, to completely sever that relationship.
Yes.
How can a president unilaterally shatter an agreement that required the explicit constitutional consent of the legislative branch to build? That feels like installing a massive bank vault door that requires 2 different managers to turn their keys to lock it, but any passing employee can just press a button from the inside to blow the door off its hinges.
That exact sense of institutional dissonance, that feeling of constitutional whiplash, is what instantly ignited a massive legal war back in Manila.
I can imagine.
You were not the only one asking how one branch of government could unilaterally undo the work of 2. Opposition lawmakers and legal scholars immediately recognized this as an existential threat to the separation of powers.
Which pulls us right into the domestic showdown. A fight over who actually holds the power to quit an international treaty.
Right.
We are looking at a consolidation of massive Supreme Court petitions filed in the spring and summer of 2018, which ultimately resulted in the 2021 landmark ruling, Pangilinan versus Cayetano.
It was a fascinating coalition that brought this fight to the Supreme Court. You had 3 distinct groups of petitioners attacking the executive's actions simultaneously.
Who were they?
First, you had a block of opposition senators, spearheaded by Senator Francis Pangilinan and Senator Franklin Drilon. Their argument was fundamentally about protecting legislative turf.
Makes sense. They want their power back.
Second, you had the Philippine Coalition for the International Criminal Court, joined by various human rights advocates who were approaching this from the perspective of civil society and victim protection.
Okay.
And third, you had the Integrated Bar of the Philippines, the official national organization of lawyers, arguing from a standpoint of pure constitutional integrity.
When you have the legislature, civil society, and the entire legal establishment teaming up to sue the president, you know you've hit a profound constitutional nerve.
Oh, absolutely.
What was the core legal theory behind their petitions?
The petitioners built their case on the doctrine of transformation.
Transformation. What does that mean?
In the Philippine system, when a treaty receives the required two-thirds concurrence from the Senate, it is transformed into domestic law. It ceases to be just a foreign policy agreement and achieves the exact same legal status as a statute passed by Congress.
So the Rome Statute wasn't just an international promise. It was a functioning piece of Philippine domestic law.
Precisely. And the petitioners argued that the president's power has limits. A president cannot simply wake up one morning and single-handedly repeal a tax law or a criminal statute just by writing a memo.
Right. Repealing a law requires an act of Congress.
Exactly. Therefore, they argued, repealing a treaty, which has the status of a law, must logically require the exact same mechanism used to enact it, a two-thirds concurrence from the Senate.
The logic there seems bulletproof.
Yeah.
If it takes two branches of government to bind the nation to a set of rules, it should take two branches to untie the knot.
That's a very strong argument.
How does the executive branch, represented by the Office of the Solicitor General, defend such a unilateral move?
The executive branch fought back with a deeply traditional interpretation of presidential power regarding foreign affairs. They argued the concept of the president as the sole organ of the nation in its external relations.
The sole organ, meaning when the country faces outward towards the rest of the world, only the president speaks.
Exactly. They argued that the Senate's power of concurrence is strictly a veto power on entry. The Constitution says the president negotiates the treaty, and the Senate can say yes or no to joining.
Okay.
But, the executive argued, the Constitution is entirely silent on the process of withdrawal. By default, that power resides entirely with the chief architect of foreign policy, the president.
So they're arguing that the two-key system only exists on the outside of the door.
Yeah.
Once you are inside the treaty, the president holds the only key to the exit.
That was the constitutional argument, yes. But they also layered in a political and sovereignty-based defense.
Which was?
They argued that the sudden withdrawal was a necessary defensive act to protect the republic. They pointed to the ICC prosecutor's preliminary examination and claimed it was a direct, hostile violation of the complementarity principle.
Ah, so using the 1998 argument against them.
Exactly. The executive's position was that their domestic justice system was fully functional, and therefore the ICC had no legal right to even begin an examination.
So they're saying, you broke the rule of complementarity, so we're tearing up the contract.
Yeah.
And there was also a highly technical argument about publication, wasn't there?
Yes, President Duterte initially threw in a procedural argument, claiming that the Philippines had never legally become a state party to begin with.
Wait, what?
He argued that the Rome Statute was never published in the official gazette, which is a standard requirement for domestic laws to become effective and binding on citizens in the Philippines.
Did that work?
The petitioners easily countered this by pointing out that treaties become effective upon ratification and the deposit of the instrument, as governed by international law and the Constitution's incorporation clause, not necessarily local publication.
Okay, so the Philippine Supreme Court is staring down an absolute constitutional impasse.
A massive one.
On one side, the argument that treaties are domestic laws that require legislative action to undo. On the other, the argument that the president is the undisputed commander of foreign policy and the guardian of national sovereignty. How did the court rule in 2021?
They delivered a ruling that was highly nuanced, deeply pragmatic, and ultimately frustrating for the petitioners.
Oh boy.
The court dismissed all the petitions. But they didn't dismiss them because they agreed with the president's absolute power. They dismissed them primarily because the petitions were deemed moot.
Mootness. The legal concept that the ship has already sailed and there is no point in a judge issuing orders to the wind. How did the clock run out on this?
Remember the speed of the executive's action? The note verbal was sent to the UN on March 16, 2018, The UN Secretary General officially accepted it the very next day.
Right.
By the time the massive legal machinery of the Supreme Court had processed the petitions, held oral arguments, and drafted a decision over the next few years, the one-year withdrawal period had already elapsed.
Oh.
On March 17, 2019, the withdrawal became an objective reality under international law.
So the executive branch effectively outran the domestic judicial process. They filed the paperwork internationally faster than the courts could issue an injunction domestically.
Exactly. The Supreme Court recognized that in the realm of international law, the acts were fait accompli already completed. Issuing an order to invalidate the withdrawal domestically wouldn't magically force the UN to tear up the withdrawal notice internationally.
The damage was done.
The court essentially admitted that it lacked the power to retroactively alter the international reality.
That feels like a massive victory for the executive branch, a total validation of the sole organ theory.
In terms of the immediate outcome, the Philippines leaving the ICC, it was a victory. However, legally and jurisprudentially, the Supreme Court completely rejected the president's claim to absolute power.
They did.
They did. They took the opportunity to explicitly define the limits of executive authority, stating clearly that the president's discretion to unilaterally withdraw from a treaty is not absolute.
This is a crucial distinction. If the power isn't absolute, what are the guardrails? When does a Philippine president actually need the Senate's permission to leave a treaty?
The court laid out a very specific roadmap for future conflicts. They stated a president cannot withdraw unilaterally if, first, the Senate originally attached a specific condition requiring their concurrence for withdrawal at the time they ratified it.
And did they do that for the ICC?
In the case of the Rome Statute in 2011, the Senate simply voted yes, without attaching any exit conditions.
Okay, so the Senate failed to protect its own future power during the original vote. What was the second guardrail?
The second scenario is if the withdrawal contradicts a prior domestic statute. Remember, Republic Act 9851, the law that localized the ICC crimes.
Yeah, the Merrill Law.
Right. The court noted that a treaty withdrawal cannot magically repeal a domestic statute. If pulling out of a treaty fundamentally violates a policy established by a domestic law passed by both houses of Congress, the president cannot act alone.
But wait, if the court laid out these guardrails and said the president doesn't have absolute power, why did the petitioning senators win their specific case regarding the ICC?
Because of a catastrophic procedural failure within the legislative branch itself.
Uh-oh.
The Supreme Court pointed out a missing key in the timeline. The Senate, as an institution, never officially fought back.
What do you mean? We just talked about Senator Pangilinan and others filing the lawsuit.
Individual senators filed the lawsuit, but the Senate, as a holistic legislative body, remained silent. During the crisis, Senator Pangilinan and a few others drafted Senate Resolution 249.
What was that supposed to do?
This resolution was designed to be the official voice of the Senate, formally declaring that termination of treaties requires Senate concurrence.
And what happened to Resolution 249?
It died. It was never tabled for a floor vote. The Senate never officially passed it.
Seriously?
Yes. The Supreme Court looked at this and essentially said, we are the referee between the branches of government, but right now the Senate isn't even on the field.
Wow.
The court ruled that they could not fight the legislature's institutional battle for them if the legislative chamber lacked the political will to even vote on its own resolution defending its own power.
That is a staggering realization. It highlights the immense difference between legal theory and raw political reality.
Absolutely.
You have a highly populist president executing a flagship domestic policy. Even if senators theoretically believed their constitutional power was being usurped, the political calculus of openly defying the president with a floor vote was too risky.
Precisely. Their political hesitation allowed the executive's unilateral withdrawal to finalize without a formal institutional block.
It is a textbook example of how constitutional checks and balances can fail, not because the law is vague, but because the actors refuse to pull the levers of power available to them.
And because the Senate remained officially silent, the domestic legal battle ended. The petitions were dismissed. The withdrawal took effect in 2019. The Philippines, legally and constitutionally speaking, had successfully abandoned the architecture they helped build.
So if we look at the board at the end of 2019, the executive branch has won. The domestic courts have declined to intervene. The Senate has stayed quiet. The Philippines is officially out. You would think the story ends there.
You really would.
You would think the international machinery simply grinds to a halt, acknowledging the sovereign exit.
You would think so. But the ICC is a different beast entirely. We are about to witness the collision between domestic political victories and the relentless mechanical progression of international law. Because the ICC didn't stop.
Not even a little bit. Let's fast forward the timeline and look at the state of play leading up to 2025. Remember that preliminary examination that Fatou Bensouda opened in February 2018? The one that triggered the whole crisis.
Right.
It quietly and methodically continued even after the Philippines officially left in March 2019.
Exactly. The Office of the Prosecutor spent years quietly gathering information, assessing the jurisdictional parameters, and monitoring the domestic investigations within the Philippines.
And then what?
And in May 2021, the prosecutor concluded that the threshold had been met and formally requested authorization from the pretrial chamber to open a full, active investigation.
The pretrial chamber grants that authorization in September 2021. And the Philippines, now technically a non-member, actually engages with the court again.
They do.
They request a deferral in November 2021, essentially saying, wait, we are investigating these things domestically under the complementarity principle.
And the ICC actually respects the process. They pause the investigation. They review the evidence provided by the Philippine government regarding their domestic proceedings.
But they weren't satisfied.
No. After a lengthy review, the ICC prosecutor concludes that the domestic efforts are not genuine or comprehensive enough to satisfy the requirements. In January 2023, the pretrial chamber authorizes the resumption of the investigation.
And the Philippines appeals.
Yes, but the appeals chamber confirms the resumption in July 2023.
The gears just keep turning. The international backup generator has officially clicked on, regardless of whether the Philippines wants it to or not.
Exactly.
And then we hit 2025, and the bureaucratic gears suddenly translate into explosive physical reality. On February 10, 2025, the prosecutor formally requests an arrest warrant for former President Rodrigo Duterte, alleging he is an indirect co-perpetrator for crimes against humanity.
And less than a month later, on March 7th, the pretrial chamber issues the warrant.
And then comes the development that shocked the international community. 5 days later, on March 12, 2025, Rodrigo Duterte is surrendered to the custody of the ICC.
He is physically transferred to The Hague.
The sheer geopolitical magnitude of that moment is immense. We will dissect the absolute paradox of why the Philippine government surrendered him a bit later, but right now, we have a former head of state sitting in a Dutch detention center.
He immediately needs a defense strategy.
Right, and his legal team, rather than attacking the facts of the investigation, files a massive challenge with respect to jurisdiction on May 1st, 2025.
It is a classic legal maneuver. If you can prove the court has no authority to hear the case, you never have to defend against the actual evidence.
The defense also attempted to disrupt the composition of the court, didn't they?
Yes, filing motions to disqualify two specific judges, Judge Alapini Gansu and Judge Flores, from hearing the jurisdiction challenge.
Let's briefly touch on that, based on our source document from June 9, 2025. The entire plenary of judges convened to hear this disqualification request. How did that play out?
It was a unanimous failure for the defense. The plenary of judges completely rejected the application to disqualify the judges. It was an attempt to shift the referees, and the institution closed ranks.
So the original judges remained, and the defense was forced to argue the merits of their jurisdiction challenge.
Which brings us to the core of their argument, and this is where we return to the middle school grammar test.
Yes, the word are.
The defense's entire strategy to free a former head of state rests on the linguistic deconstruction of a single sentence in Article 12, Paragraph 2 of the Rome Statute.
It is a masterclass in pedantic legal parsing. Let's look at the exact text. Article 12.2 dictates the preconditions to the exercise of jurisdiction. It states that the court may exercise its jurisdiction if the state on whose territory the conduct occurred, quote, are parties to this statute.
Are parties, two relatively innocuous words.
How does the defense build a wall out of them?
The defense hones in on the present simple tense of the verb are. They build a strictly temporal argument. They assert that the use of the present tense means a state must be an active, current party to the statute contemporaneously with the exact moment the court decides to exercise its jurisdiction.
So they are tracing a timeline.
Yes.
They are saying to the ICC, you are attempting to exercise jurisdiction right now by issuing an arrest warrant in 2025. Look at the map in 2025. The Philippines officially left in 2019. Therefore, today, the Philippines are not a party. They were a party. Because the condition requires them to be a party in the present tense, The precondition fails. You have no jurisdiction, case closed, release the prisoner.
That's exactly it.
You know, I have to play devil's advocate here, even though it feels absurd. As you said earlier, treaties are meticulously drafted documents. Sovereignty is surrendered comma by comma.
Right.
If a sovereign nation agrees to be subject to an international body, shouldn't their ongoing consent be required? If they withdraw that consent, shouldn't the jurisdiction instantly evaporate?
Well,
I mean, if I sign a contract agreeing to employee arbitration and I quit the company, you can't force me into employee arbitration 3 years later for something I allegedly did while I worked there, if the contract explicitly says it applies to people who are employees.
that is exactly the rhetorical weight the defense is relying on. They are banking on a strict, literalist interpretation of the text to protect the ultimate concept of state consent.
They want it taken literally.
They are arguing that international jurisdiction isn't a trap you fall into forever. It is a consensual relationship that ends the second the paperwork is finalized.
But the Office of Public Counsel for Victims, the OPCV, represented by Principal Counsel Palin and Machina, does not accept this grammatical escape hatch.
No, they don't.
Their June 9th, 2025 filing is a systematic dismantling of this literalist defense. How do you defeat a grammar argument in a court of international law?
You don't argue grammar, you argue purpose. You elevate the debate by bringing in the supreme rule book of international law, the Vienna Convention on the Law of Treaties.
The Vienna Convention, the Treaty on Treaties, the meta rule book that tells judges how to read other rule books.
Exactly. The ICC Appeals Chamber has firmly established that interpreting the Rome Statute must be done in accordance with the Vienna Convention, specifically Article 31.
What does Article 31 say?
This article lays out the principal rule of interpretation. It states that a treaty must be interpreted in good faith in accordance with the ordinary meaning of its terms. So, yes, you look at the words, but, and this is the vital caveat, you must look at those words in their context and in light of the treaty's object and purpose.
You cannot isolate a single verb under a microscope, divorce it from the rest of the document, and use it to break the entire machine.
Precisely. The OPCV argues that applying a hyperliteral grammatical reading of are creates a result that is manifestly absurd and entirely destructive to the treaty's existence.
How do they prove that?
To prove this, they direct the judges to the preamble of the Rome Statute, which explicitly defines the treaty's object and purpose.
What does the preamble say? What is the fundamental point of the ICC?
The preamble is a profound statement of global morality. It states that the state's parties are mindful that millions of children, women, and men have been victims of unimaginable atrocities that deeply shock the conscience of humanity.
Right.
It affirms that the most serious crimes of concern to the international community must not go unpunished. And it declares that the overriding determination of the court is to put an end to impunity.
To put an end to impunity. That is the North Star of the entire document.
And the OPCV points out that the appeals chamber, as recently as the Joseph Kony appeal judgment just days prior on June 3, 2025, reaffirmed this exact point.
Okay.
Ending impunity is the overarching purpose. If you accept the defense's grammatical argument that a state can commit mass atrocities, realize an investigation is looming, file a one-page withdrawal letter, wait a year, and achieve total permanent immunity from prosecution, you have entirely defeated the object and purpose of the Rome Statute.
You haven't ended impunity. You've created a legal roadmap for it.
Exactly.
It turns a global human rights treaty into an honor system for dictators. But the OPCV doesn't just rely on the philosophical spirit of the law, right? They also have specific textual ammunition. They point to the actual escape hatch built into the treaty.
Yes. In legal theory, there is a concept called lex specialis, which means that a specific law overrides a general law.
Okay.
While Article 12 talks generally about jurisdiction, Article 127 is the lex specialis governing the exact mechanics of withdrawal. And Article 127 is devastating to the defense's timeline.
Let's read the specific text of Article 127, paragraph 2. It says, "A state shall not be discharged by reason of its withdrawal from the obligations arising from this statute while it was a party to the statute."
That sentence alone destroys the idea of retroactive immunity. It explicitly says that leaving the treaty doesn't wipe your slate clean for things you did while you were a member.
But the kicker is the second half of that sentence. It says the withdrawal shall not prejudice in any way the continued consideration of any matter which was already under consideration by the court prior to the date on which the withdrawal became effective.
Now let's overlay the actual timeline of events onto that legal requirement.
Let's do it.
The prosecutor formally opened the preliminary examination into the Philippines on February 8, 2018. The The Philippine withdrawal did not become legally effective until over a year later, on March 17th, 2019.
Right.
The examination started before the withdrawal took effect. Therefore, strictly according to the text of Article 127, the withdrawal cannot prejudice the continued consideration of that matter. The timeline locks them in.
It seems so mathematically simple. Event A happened before Event B, therefore the rule applies.
Yeah.
But the defense lawyers are highly skilled. How on earth do they try to wriggle out of a timeline that explicit?
They attempt another linguistic maneuver, this time focusing on a semantic debate over the definition of 3 words. By the court.
By the court.
Yes. The defense argues that the preliminary examination launched by the prosecutor in 2018 doesn't actually count as a matter under consideration by the court.
Wait, they are seriously arguing that the prosecutor of the International Criminal Court is not part of the International Criminal Court.
It sounds wild, but they built a very dense argument around it. They systematically analyzed the entire statute and the rules of procedure, claiming that in almost all instances, the term by the court refers strictly and exclusively to the judicial organ, the judges.
Wow.
They argued that a preliminary examination isn't even a real formal procedural phase in the statute. They dismissed it as a mere catch-all phrase for internal, informal deliberations happening within the office of the prosecutor.
So their logic is, sure, the prosecutor was looking into us in 2018, but the prosecutor isn't the court. No actual judges were considering anything regarding the Philippines until long after we left in 2019. Therefore, there was no matter under consideration by the court prior to our exit.
Exactly. They are trying to sever the investigative arm from the judicial body to exploit a perceived loophole.
If that argument holds water, the implications are terrifying.
Very much so.
If the phrase "the court" doesn't include the prosecutor's early investigations, then any member state could simply monitor the prosecutor's office. The moment they realize a preliminary examination is gathering steam, but before the prosecutor officially hands a dossier to a pretrial judge, the state could instantly hit the withdraw button, wait out the clock, and permanently kill the investigation.
It would render the prosecutor completely impotent.
So how does the OPCV counter that?
The OPCV systematically dismantles this argument, and they don't have to resort to abstract philosophy to do it. They just read the foundational definitions within the Rome Statute itself. They point the judges directly to Article 34.
What does Article 34 do?
Article 34 literally explicitly defines the composition of the court. It lists the organs that make up the entity known as the International Criminal Court. Organ A is the presidency. Organ B is the appeals, trial, and pretrial divisions. Organ D is the registry. And wedged right there in the middle, explicitly defined as Organ C of the court, is the Office of the Prosecutor.
So the text of the treaty itself categorically refutes the defense's argument. The prosecutor is, by definition, an organ of the court.
Yes. Furthermore, the OPCV shreds the idea that a preliminary examination is just informal internal chatter.
Uh-oh.
They point to Article 15, which outlines a highly formal, structured process. During a preliminary examination, the prosecutor must analyze the seriousness of the information, actively seek additional information from states or NGOs, and make formal, recordable determinations.
It's not just a casual chat.
No. Previous ICC pretrial chambers have consistently ruled that the preliminary examination is an important formal phase of the legal proceedings, not just a brainstorming session.
So the grammar argument regarding our parties fails because it violates the fundamental object and purpose of the treaty to end impunity. And the semantic argument regarding by the court fails because the treaty explicitly defines the prosecutor as an organ of the court engaged in formal proceedings. The defense's linguistic shields are essentially dissolving upon contact with the actual text.
And if there was any lingering doubt whatsoever about what the drafters intended when they wrote Article 127 back in the 1990s, the OPCV plays their trump card. We don't have to guess if the drafters accidentally created a grammatical loophole. We can look at their meeting notes.
This brings us to my absolute favorite part of international legal argument, the drafting history. When the text is debated, you can look back at the actual rooms where the architects argued over the blueprints.
In international law, this is known as resorting to the travaux préparatoires, the preparatory work. Under Article 32 of the Vienna Convention, if interpreting the text still leaves the meaning ambiguous or leads to an absurd result, you are allowed to dig into the drafting history to find the original intent.
And the OPCV takes the judges right back to the smoky drafting rooms between 1993 and 1998.
They do.
What were the drafters saying back then about the risk of countries trying to flee the court's jurisdiction? Did they anticipate a Duterte-style sudden exit?
They didn't just anticipate it, they were obsessed with preventing it. From the very first draft produced by the International Law Commission in 1993, the text explicitly stated a core principle. Withdrawal does not affect proceedings already commenced under this statute.
That's pretty clear.
That concept survived multiple intense iterations through 1996 and 1997. But the real gotcha moment in the OPCV filing comes from the interventions of non-governmental organizations during the final drafting push.
The sources highlight a specific warning submitted by Amnesty International in March 1998, just months before the Rome Conference. What did they say?
Their warning is chillingly prescient. Amnesty International submitted formal commentary to the drafters, noting that the withdrawal provision needed to be incredibly strict. They explicitly warned that the wording must be bulletproof to, and I'm quoting their submission here, avoid an incentive for certain states to denounce the statute when they fear that a concealed massacre is about to be discovered or that an investigation is likely to be opened concerning crimes which are known.
That is incredible. Decades before the Philippine War on Drugs, Amnesty International essentially described the exact scenario the ICC is alleging happened in 2018. They warned that a state would use withdrawal as a tactical smokescreen to hide a massacre.
The drafters heard that warning loud and clear. Another major NGO coalition also lobbied heavily, urging that any withdrawal must not affect the court's powers with respect to acts occurring before the submission of the notice.
So they closed the loophole.
The final version of Article 127 that was adopted at the Rome Conference, the very conference where the Philippine delegation was actively participating and voting, was intentionally, specifically designed to board up this exact loophole.
They made sure of it.
They ensured that once the gears of justice start turning, even at the preliminary examination stage, pulling the plug on your membership does not and cannot stop the machine.
The original intent is crystal clear. The drafters saw the get-out-of-jail-free card coming from a mile away and deliberately shredded it. But the OPCV filing has one final, brilliant legal maneuver.
Oh, this is the best part.
They don't just rely on text or history or philosophy. They rely on the ultimate paradox of reality. They look at what the Philippines actually did.
This is perhaps the most devastating argument in the entire document, relying on the concept of subsequent practice.
Subsequent practice.
Under Article 31 of the Vienna Convention, when interpreting how a treaty applies, a court must take into account any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation.
Basically, actions speak louder than legal briefs.
Yes.
How a state actually behaves in the real world reveals how they truly interpret their obligations, regardless of the grammatical gymnastics their defense lawyers are attempting in court.
Exactly. And the twist here is based on the most objectively factual, undeniable event in this entire timeline. The OPCV asks a very simple question.
Which is?
If the Philippine government genuinely believed the legal arguments submitted by Duterte's defense team on May 1st,
If they really believed it.
if they truly constitutionally believed that the ICC's jurisdiction entirely evaporated in March 2019 due to the word R, why did the Philippine government voluntarily surrender Rodrigo Duterte to the ICC on March 12, 2025?
That is the ultimate checkmate. If you honestly believe the International Court has the legal authority of a neighborhood book club, you don't put your former president on a plane to The Hague.
You absolutely do not. The OPCV points out that by complying with the arrest warrant, by utilizing their domestic law enforcement to apprehend the suspect, and by physically handing him over to the custody of the court, the Philippine government objectively demonstrated through its actions that they still consider themselves bound by the statute's obligations for crimes committed during their membership.
Their physical compliance completely validated the ICC's jurisdiction, destroying their own legal defense.
The Principal Counsel calls it an irrefutable proof. The sovereign state of the Philippines, through its execution of the warrant, aligned perfectly with the OPCV's interpretation, that the court maintains absolute jurisdiction over crimes committed while the state was a party, provided the preliminary examination started before the withdrawal took effect.
So the grammar debate is dead.
The debate over are versus were is rendered entirely moot by the reality of the handcuffs.
We have spent the last hour unpacking an incredibly dense legal thriller. We've gone from the architectural optimism of the 1990s to the abrupt geopolitical pivot in 2018 through a domestic constitutional crisis where the legislature blinked, and finally to a high-stakes grammatical battle in The Hague that was ultimately undone by the reality of a physical surrender.
It's a massive journey.
But as we step back from the jurisprudence, we have to remember the core reality of this deep dive.
The human reality. That is the most crucial element to retain. The OPCV filing, for all its brilliant dissection of the Vienna Convention and drafting history, does not end on a note of academic triumph.
No, it ends by centering the voices of the victims.
Exactly.
The principal counsel notes that the victims they represent have expressed profound existential concern at the possibility that the proceedings against Duterte could be halted if the defense's grammatical challenge is somehow successful.
The human toll here is immense and ongoing. The filing details how terrified the victims are. They express the view that if the court chooses to uphold the defense's overly restrictive, literalist reading of the statute, and the suspect is released from custody and returned to the Philippines, the result will be absolute crushing impunity.
If the loophole works, justice evaporates.
They fear they will have zero judicial recourse. They have no hope of pursuing accountability domestically, given the political realities that led to the ICC investigation in the first place.
Okay.
And practically, they fear direct, severe physical threats to their lives from the suspect and his entrenched network of supporters if he returns unpunished. For the victims, accountability cannot be a theoretical concept contingent on the present tense of a verb. It must be a certainty.
And this connects directly back to you, listening to this deep dive. Why should you care about the minutia of a jurisdictional challenge happening in a courtroom in the Netherlands? Because this case represents the ultimate defining stress test for international law in the 21st century.
It forces us to confront a fundamental question about the global order. Are international human rights treaties actual ironclad laws capable of holding the most powerful individuals on earth to account? Or are they just fragile, performative gentlemen's agreements that can be shredded the moment they become politically inconvenient for those in power?
If a sovereign state can spend a decade building a court, pass domestic laws supporting it, but then instantly hit an eject button the moment its own leaders face scrutiny, claiming immunity based on a single word, then the entire architecture of international justice is inherently flawed.
The ruling that the ICC plenary of judges eventually hands down on this jurisdictional challenge won't just affect Rodrigo Duterte. It will establish a permanent precedent that will echo globally for decades. It will tell every autocrat, every warlord, and every human rights victim whether the system is real or whether it's an illusion.
We started this deep dive talking about the predictability of contracts and insurance policies. The expectation that if you sign the paper, the rules apply, and you can't cancel the policy after you crash the car. What we have examined today is a desperate attempt by a sovereign power to do exactly that, met by an international legal mechanism fighting with everything it has to enforce the original terms of the agreement.
Exactly.
The outcome of this clash between sovereign escape attempts and global accountability will quite literally define the future of the ICC. Before we go, I want to leave you with a final provocative thought to mull over.
Yes, think about this.
Consider the ultimate paradox of international justice that this entire saga highlights. The ICC, for all its grand architecture, its brilliant lawyers, and its towering judges, relies entirely on the voluntary cooperation of sovereign states to enforce its will. The ICC does not have a standing army. It does not have a global police force.
It relies on the nations themselves.
If the government of the Philippines, for whatever internal political reasons they may have had in March 2025, had simply refused to execute that arrest warrant, if they had ignored the ICC and kept Duterte safely at home, all the flawless grammatical arguments, all the deep dives into the 1998 drafting history, and all the brilliant appeals to the Vienna Convention would have been functionally useless. The Hague would have remained empty.
It all comes down to action.
So ask yourself, does true lasting justice in our world ultimately depend more on the precise, bulletproof wording of an international treaty or on the raw, unpredictable political willpower of nations on any given Tuesday? Thank you for joining us for this deep dive. Stay curious, keep asking the hard questions, and keep unpacking the world around you.
Welcome to the debate. Today we are unpacking what might be one of the most fascinating and frankly complex legal collisions in modern international law.
Yeah, it really is the ultimate international paradox.
Exactly. We're looking at the tension between state sovereignty and international justice. Specifically, the International Criminal Court proceedings against former Philippine President Rodrigo Roa Duterte.
Right, stemming from his government's war on drugs.
Yes, and the timeline here is, well, it's pretty wild. So the Philippines accedes to the Rome Statute, that's the treaty governing the ICC back in 2011. Fast forward to February 2018, and the ICC prosecutor opens a preliminary examination into these alleged crimes against humanity.
And then literally 1 month later, the Philippines announces it is formally withdrawing from the Rome Statute entirely.
Right. They just pull the plug. And that withdrawal officially takes effect in March of 2019. But the court didn't stop. They authorized a formal investigation, issued an arrest warrant in 2025, and then in this stunning twist, the Philippine government actually surrendered Duterte to The Hague in March 2025.
Which, of course, instantly triggered a massive jurisdictional challenge from the defense.
Exactly. So our central question today is this. Does a state's withdrawal from the Rome Statute immediately strip the ICC of jurisdiction over crimes committed during its membership, especially when a preliminary examination had already commenced prior to the withdrawal?
It's a huge question.
It is. I'll be representing the perspective of the Office of Public Counsel for Victims, or the OPCV. The argument here is that the ICC firmly retains jurisdiction because, withdrawal cannot retroactively erase obligations or halt proceedings that were already set in motion.
And I'll be taking the defense's perspective, arguing for a strict text-based interpretation of the Rome Statute. Basically, when a state effectively withdraws, the preconditions required for the court to actively exercise its jurisdiction simply evaporate.
Right. So let's jump straight into the position statements. From the OPCV side, we argue that the ICC inherently retains jurisdiction over crimes committed on Philippine territory between November 2011 and March 2019.
The active membership period.
Exactly. And we base this on the lex specialis of the Rome Statute. That's Article 127, Paragraph 2. This is a specific survival clause that overrides general principles, and it explicitly states that withdrawal shall not prejudice in any way the, and I'm quoting here, continued consideration of any matter which was already under consideration by the court. Because the prosecutor opened a preliminary examination on February 8, 2018, well before the March 2019 effective withdrawal date. The matter was actively under consideration. Interpreting the statute to allow a state unilaterally to strip the court of jurisdiction just to dodge an impending investigation, it completely defeats the fundamental object and purpose of the treaty, which is, of course, to end impunity for the gravest crimes.
I hear that. But we have to look at the defense's position, which centers on how international law fundamentally operates. While the court may have had theoretical jurisdiction over that timeline, the preconditions for exercising that jurisdiction completely vanished when the withdrawal took effect on March 17, 2019.
Because of the grammar in Article 12?
Yes, precisely. We base this on a strict grammatical reading of Article 12, Paragraph 2. It sets the baseline for jurisdiction, and it uses the present simple tense. It says, the court may exercise jurisdiction if the relevant states, quote, are parties to this statute.
Right, are parties.
Are parties. It doesn't say were parties. Are requires contemporaneous membership at the exact moment the court attempts to exercise its jurisdiction. Plus, a preliminary examination by the prosecutor is, frankly, merely an internal administrative deliberation. It's not a formal procedural phase handled by the judicial organ, the judges, so it doesn't even qualify as a matter under consideration by the court under Article 127.
Okay, so let's dig into that first major point of contention. You're really leaning heavily into the present tense of our parties. You're saying grammar dictates global accountability?
Well, I'm saying that in international treaty law, grammar is the architecture of state consent. You have to remember, there is no global police force, right? International tribunals rely entirely on the voluntary consent of sovereign states.
Sure, consent is foundational.
Right. So, any treaty must respect that sovereignty. You cannot ignore the choice of the present tense. It binds the court's authority directly to the current sovereign status of the state. When the Philippines left in 2019, they were no longer a party. That precondition is gone.
Let me push back on that with an analogy. Consider a complex commercial contract with a survival clause. You cannot simply cancel your gym membership and claim you're no longer liable for the equipment you broke while you were an active member.
A sovereign state isn't a gym member, though.
No, but the legal mechanism is similar. Under the Vienna Convention on the Law of Treaties, which is the master rulebook here, words cannot be read in total isolation. Article 12 is the general rule, but Article 127 acts as the specific survival clause, the leg specialist. It specifically protects proceedings from these sudden unilateral sovereign withdrawals.
But a corporation or a person exists under a national government that enforces that liability. A sovereign nation answers to no higher authority than itself, unless it explicitly consents to do so at that exact moment.
But they did consent to the survival clause when they joined. In 2011, they signed Article 127 along with the rest of the treaty.
I agree they signed it, but treaties are not irrevocable traps. If you trap a state inside a judicial system it has formally, legally chosen to exit, the entire architecture of global cooperation starts to crack. No state will ever feel safe signing a treaty again if they think they can never truly leave.
I don't think it's a trap, it's just following the agreed-upon exit rules. But let's shift to your other point, the definition of the court and any matter. Because this is where the survival clause gets triggered.
Right. And the systematic analysis of the Rome Statute strongly supports the defense here. Let's look at what Article 127 protects. Any matter which was already under consideration by the court. The operative words are by the court. If you comb through the statute and the rules of procedure and evidence, you'll see that by the court refers almost exclusively to the judiciary, the pretrial chambers, the trial chambers. It does not refer to the prosecutor.
Oh, I have to challenge that directly. That artificially separates the prosecutor from the court to create a massive loophole.
How is it artificial?
Because of Article 34. If you look at the structural anatomy of the ICC in Article 34, it explicitly lists the four constituent organs of the court. It lists the presidency, the chambers, the registry, and, right there, the office of the prosecutor. The prosecutor is structurally and legally part of the court.
Structurally, yes, I'll grant you that. But functionally, no. And the functional mechanism is what matters for jurisdiction.
How so?
A preliminary examination isn't an action by the court in a judicial sense. It's largely an internal desk review. It's the prosecutor sitting in The Hague, reviewing news reports, reading NGO communications, and just, deciding if there might be a reason to ask the judges for an investigation later.
You're calling it a desk review?
I am. The judges haven't weighed in. There are no formal charges. Are you really arguing that if a prosecutor merely opens a manila folder and thinks about investigating, a sovereign country is locked into a treaty indefinitely?
It is vastly more rigorous than just opening a manila folder. Under Article 15, the preliminary examination is a formal, rigorous stage of proceedings. The prosecutor doesn't just read the news. She must analyze the seriousness of the information, establish a reasonable basis to proceed, evaluate admissibility, and weigh the interest of justice.
It's still prejudicial, though.
But it's formal action. Various pretrial chambers have consistently recognized it as a vital step in the judicial machinery. It is the active consideration of a matter.
The danger here, from the defense's point of view, is teleological overreach.
Meaning what, exactly?
Meaning you are applying modern, expansive visions of justice to override the exact compromises states made when drafting the treaty. The drafters in 1998 were terrified of an unchecked, runaway prosecutor. That fear is baked into the document. If you interpret any matter so broadly that internal prosecutorial analysis permanently strips a state of its sovereign right to leave, you're rewriting the treaty.
Well, if we want to talk about the intent of the drafters, let's look at the travaux préparatoire, the actual drafting history, because that history completely dismantles the idea that withdrawal was meant to be a clean break.
I think the drafting history is much more ambiguous than you're suggesting.
I don't think it's ambiguous at all. During the 1998 Preparatory Committee and the Rome Conference, the issue of states using withdrawal as a shield was front and center. Amnesty International specifically lobbied the drafters about this.
Right, the NGO memos.
Exactly. They submitted a memo explicitly warning that states might denounce the statute when they fear that a concealed massacre is about to be discovered. They warned regimes would hit the eject button to avoid accountability.
But advocacy from an NGO doesn't equal the legal intent of sovereign states. NGOs lobby for maximalist human rights positions all the time, and states reject them all the time to preserve sovereignty.
Except in this specific case, the drafters deliberately adopted the core of that warning. The original draft text for the withdrawal clause was super narrow, but after that lobbying, they deliberately expanded Article 127 to ensure withdrawal wouldn't prejudice the continued consideration of any matter. They adopted that language to close the impunity gap.
Actually, if you look at the exact edits made in Rome, they point the other way. The delegates had a draft that said withdrawal does not affect proceedings already commenced, and they affirmatively debated and deleted the word proceedings.
Yes, they replaced it.
They replaced it with matter under consideration by the court. That was a deliberate choice to narrow the survival clause to formal judicial matters, not to expand it to cover whatever internal investigations a prosecutor is running.
I see it the exact opposite way. Any matter is vastly more comprehensive than proceedings. Proceedings could be interpreted strictly as formal courtroom trials. By changing it to any matter, the drafters ensured that all phases, including preliminary examinations, were protected.
Well, we can debate 1998 conference room definitions all day, but we really need to look at the subsequent state conduct and domestic law. We have to look at the real-world mechanics of the withdrawal.
Okay, let's look at it.
In 2018, the Philippine president made a sovereign executive decision to withdraw, and the Philippine Supreme Court in Pangilinan versus Cayetano formally ruled on this. They acknowledged the president as the primary architect of foreign policy. This wasn't a clerical error. It was a valid, completed executive act, officially received by the UN Secretary General.
Right, no one is debating the administrative validity of the withdrawal document.
But the implication is that the one-year clock ran out in March 2019. To pretend that this massive, constitutional, geopolitical act has zero effect on a prosecutor's ability to issue warrants in 2025, it completely disrespects the domestic legal order of a sovereign nation.
We aren't pretending it has zero effect. We are applying the consequences of it as agreed to in the treaty. And if you want to talk about real-world conduct, let's talk about the elephant in the room, 2025.
The surrender of Mr. Duterte.
Yes. If the Philippines successfully totally withdrew in 2019, why on earth did they voluntarily surrender him to the ICC in March 2025, 6 years later?
As the defense would argue, that was a political decision, not a legal one.
It has massive legal significance. Under the Vienna Convention, there is a concept called subsequent practice. It basically says that when interpreting a treaty, you have to look at how the parties actually behave afterwards to establish their agreement on its interpretation.
Yes, but...
And the Philippine government voluntarily surrendered him. If the state genuinely believed the court had zero jurisdiction, they never would have handed over a former head of state. That objective action proves the state itself recognized the ongoing binding nature of the arrest warrant.
I disagree entirely. A political decision by a subsequent administration in 2025 to hand over a political rival does not retroactively alter the legal interpretation of a 2019 treaty text.
It's not retroactive. It's subsequent practice confirming the ongoing obligation.
Extraditions and surrenders happen constantly in international relations for diplomatic, economic, or purely domestic political reasons. They happen completely outside the strict bounds of treaty obligations. The fact that the 2025 government cooperated just means it was politically expedient to put him on a plane. It doesn't mean the court legally possessed the jurisdiction to demand it.
But the substantive legal obligations were already embedded in their own domestic law. Back in 2009, the Philippines passed Republic Act No. 9851, criminalizing these exact international crimes. The obligations never left Philippine law. The 2025 surrender is the logical legal conclusion of an obligation born in 2011, triggered by the prosecutor in 2018, and preserved by Article 127.
But the existence of that very domestic law, Republic Act 9851, is exactly why the ICC shouldn't be involved at all. This brings us to the principle of complementarity.
The idea that the ICC is a court of last resort.
Exactly. Think of complementariety like a federal backstop. The Rome Statute explicitly says the court only steps in if the local justice system is completely broken, unwilling, or unable to prosecute. Because the Philippines has a robust domestic law and functioning courts, the international system is supposed to step back. The 2018 withdrawal was a principled stand asserting that their domestic courts were fully capable of handling this without Hague interference.
Complementarity is a great shield, but only if the state is actually investigating and prosecuting the high-level architects of the crimes. Passing a law in 2009 is wonderful, but if the state apparatus in 2018 is shielding the architects of the drug war, the ICC is legally triggered to step in. That's precisely why the prosecutor found a reasonable basis to advance the examination.
The prosecutor can believe whatever she wants about the domestic system, but we keep circling back to the immovable boundary of international law. She cannot exercise jurisdiction over a state that is no longer a party. The text remains our parties. If you bypass the strict text of Article 12, you bypass the foundation of state consent.
And I'll counter that by saying the text of Article 127 explicitly commands that withdrawal shall not prejudice in any way the continued consideration of a matter.
It really is a fascinating structural tension. From the defense's view, we have to conclude that treaties are not suicide pacts. A strict grammatical reading of the Rome Statute requires active membership for the court to wield power.
Right.
And interpreting the court to mean the judicial chambers, not an investigating prosecutor, respects that crucial boundary between formal legal proceedings and administrative fact-finding. Holding on to jurisdiction 6 years after a formal withdrawal, based just on a prosecutor's preliminary examination, it stretches treaty law past its breaking point.
Well, to summarize the OPCV and victims' perspective, the case for continuing jurisdiction isn't just morally imperative, it's legally airtight. You cannot read jurisdictional clauses in a vacuum. The specific survival rules in Article 127, the heavily documented intent of the framers to close the impunity gap, and the Philippines' own 2025 surrender all show that a preliminary examination locks in the court's authority.
It's a tough balance.
It is, because if we allow states to commit atrocities, wait for an international prosecutor to start asking questions, and then simply hit an eject button to avoid a trial, we render the entire Rome Statute totally meaningless.
But again, if you lean too far toward that human rights imperative, stretching the text to ensure a conviction, you erode the legal certainty states rely on. If states feel they can never truly leave, they'll just never join these international bodies in the first place.
And conversely, if you prioritize the present tense of a single verb over a dedicated survival clause, you create a world where international justice is just an illusion, a system that can be discarded the moment it becomes inconvenient for the powerful.
It's a question that challenges the very architecture of international law. Balancing global accountability with sovereign boundaries is incredibly delicate, and there's clearly a lot more to explore in the source material.
Absolutely. We'll leave it to the listeners to weigh these perspectives. Thank you for joining us for this exchange.